Welcome to Clarity Education Systems. Today, we're going to quickly review some of the most important court cases associated with mental health in the U.S. It is important to commit each one of these to memory. Number 1, Durham v. United States. In this 1954 ruling by the U.S. Court of Appeals, it stated that an accused is not criminally responsible if his or her unlawful act was the product of a mental disease or mental defect. This rule has been replaced by the American Law Institute Model Penal Code Insanity Test. So, under the Durham test, a defendant is entitled to an insanity defense if their legal conduct is the product of a mental disease or defect. Number 2, OConnor v. Donaldson. In this case, the court held that mentally ill persons are entitled to due process. In other words, if the individual is not posing a danger to self or to others and is capable of living without state supervision, the state has no right to commit the individual to a facility against his or her own will, simply because he or she has a mental illness. Number 3, Renee v. Klein, 1979. A 38-year-old named John Renee was a patient at a state hospital in New Jersey. His case established that an involuntary committed patient that was legally competent could refuse medication, and they had a right to professional medical review of the treating provider's decision based on their specific case. 4, Rogers v. Okin, 1981. This landmark court case by the U.S. Court of Appeals considered whether a person diagnosed with mental illness committed to a state psychiatric facility and assumed to be competent has the right to make treatment decisions in non-emergency conditions. The ruling found that involuntary hospitalized patients with mental illnesses and deemed competent have that right to make treatment decisions on their own. Number 5, Dusky v. U.S., 1960. This case involved a schizophrenic man that was charged with kidnapping and rape. After a brief evaluation, the patient was convicted. However, it was argued that his conviction was unconstitutional based on the fact that he did not receive a full psychiatric evaluation. The court reasoned that to be competent to stand trial, a defendant must have sufficient ability to rationally consult with his or her lawyer and have a rational and factual understanding of the court proceedings. Number 6, Tarasoft V Regents, 1976. In this case, a patient told a psychotherapist that he intended to kill a woman, which he subsequently did. The parents of the murdered woman sued the therapist for failing to warn about the danger. The California Supreme Court held that mental health professionals have a duty to protect individuals who are being threatened with bodily harm by a patient. Although this has been adopted by many states, it is important that the practitioner verify with the State Board of Nursing in the state where they practice as to the legal obligations involving a provider's responsibility to warn potential victims. Number 7, Ford v. Wainwright, 1986. This case reviewed the constitutionality of executing an incompetent patient. The U.S. Supreme Court decided that it is a violation of a person's Eighth Amendment rights and considered cruel and unusual punishment when inflicting the death penalty ruling on a prisoner who is deemed clinically insane. Okay, now you know many of the landmark cases that exist in the United States for the protection of both patients and clinical providers. Court cases have evolved over the years, and it is vital that the nurse practitioner check with his or her State Board of Nursing regarding current practices and laws governing the care and practice of mental health patients. Thank you for joining us. We look forward to seeing you in one of our live or on-demand PMHNP review seminars.